The UK's approach to trademark remedies, and in fact all IP remedies, has really changed over the last 3 to 4 years. The courts have now woken up to the fact that an EU law from several years ago, the Enforcement Directive, gives them a lot of flexibility on how to approach things and not stay with the traditional ways of approaching it. So now what courts do is they look first at the actual prejudice suffered by a claimant, and then what's the fair, dissuasive and proportionate way of dealing with that. Publicity orders are relatively new and they're potentially a really powerful remedy. They involve the court ordering one of the parties to take out an advertisement in a newspaper, to put notices on their websites about the results of the case and to publicise it. The thinking behind them is that they deal with things like confusion in the marketplace between two products. They have another effect, which is that they really focus parties' minds on how to settle a dispute and avoid the publicity and, frankly, the humiliation that comes with one of these orders.
When it comes to accounts of profit, there have been some recent changes which are definitely favourable for IP owners. In the past, I think by way of background, to start with, the claimant always has a choice at the end of a case whether to claim from the defendant either damages, which is more based on the loss that the claimant himself has made, or an account of profits, which is the profits which the defendant itself has made from its infringements. And previously, an account of profits has tended to be seen as not a popular option, and the reason for that is it was perceived, at least, that it would always lead to quite a low figure. That coming out of a case called Remedies v. BP, where the judge ruled that the general overheads of the defendant could be deducted from the figures, which in turn led to pretty low overall figures being granted. But that's changed recently as a result of a Court of Appeal case called Hollister, where the court ruled that general overheads don't need to be deducted, generally speaking, and the only time when they should be is essentially when those overheads have increased because of the infringing activities, and then only to the extent of that increase. When it comes to the court order after an IP trial, I think most people have always tended to think that's the easy bit and the job's finished by the end of the trial and the form of order just follows in a normal way, almost what you might say on the nod, without having to think very hard about it. Whether or not that really was the case in the past, it's definitely not now. Because of the IP enforcement directive coming in, there's a lot more factors to take into account, which means in turn that the parties have a lot more to argue with and the courts have a lot more to consider.